Hello and welcome to another Let's Talk IP Artist Edition.
Artist Edition.
Artist Edition. I'm sitting with Ezra. Some of you might have seen him and remember him as our guest from the first video we had. What an interesting chat that was, and a long chat.
It was a long chat.
About AI.
Very long.
We're not doing AI today.
Yeah, definitely not.
Yeah. So before we go into the topic, Ezra, introduce yourself again.
Yeah. I'm Ezra, so I'm a local character designer and illustrator, and I also do some watercolor paintings. I've been doing art for the past 3 years now. Actually celebrating my business in April, so that's very exciting.
Awesome.
Yeah. And released the book, so go check that out if you want to learn how to draw characters. But I'm very excited to chat with you today, Christiaan, on a very interesting topic once again.
Once again, yeah. So we decided we spoke about this a bit, and said we have to do a new chat. And originally it would have been a art and AI 2.0, and then we realized no, that's a rabbit hole. That's not today. And then after going through topics, we came about like, what is the issue of artists? An issue in the sense that what's the misconceptions about intellectual property in the art industry, or specifically your genre, your related genre of the art industry. So we're not focusing on art in general. We're focusing on more contemporary style art, more fan art style stuff, more
digital
art. Renderings, or the like that I want to say modern, but not modern art in the sense of it, but more current iterations of art. Yes, most of it would be applicable to older styles and things like that, but for the sake of it, let's just make it clear to the viewers that this is not a global all coverage of any art form. It is purely intellectual property in relation to Ezra style art and art similar there too. And I think before we go into the chat, the main thing, and I know this is usually a comment and a question that comes up, is, but what aspects of intellectual property is related to my business? So let's cross that hurdle. So when we look at intellectual property in relation to a specific industry, in this case the art industry or the creative art industry, we would say yes, there's four main bodies of intellectual property: patents, designs, copyright, and trademarks. Now, patents in the art industry, although it might sometimes be there, is very, very limited. So for the sake of the discussion, we're not looking at patents. Patent covers innovation and invention.
Yeah.
Then we have designs, industrial designs, for the lack of a better word, which focuses on the functionality and aesthetics of products. So although not really relevant, you might see relevance in design rights in South Africa specific, where somebody, for instance, reproduces on a larger scale some of their figurines they might have created, original figurines.
Right.
Then you can look at design rights. But it's not really that common. This is more for artists that make series of things that gets commercialized.
Right.
Most art focuses around copyright. So our discussion will be copyright orientated, copyright in relation to art, and then a bit of trademarks, because trademarks at the end of the day, as you know, you know me for a while now, trademarks is very essential to every single business and entrepreneur and industry, irrespective of what it is. Your trademark is essential. But let's do that at the end. Let's not make this a trademark discussion. Let's make this a copyright discussion.
Bit of close off.
So, when we look at copyright, and you know this, your main focus in the art industry is to realize that copyright isn't broad-based, blanket over every single thing.
Yeah.
Copyright will differ from industry to industry, from situation to situation, how it's applied, how it works, what is covered, things like that. There is in South Africa, Copyright Act dealing with it. There is current amendments to the Act, which hasn't passed yet, although we assume it will.
Okay.
But we are focusing on the current Copyright Act.
Yeah.
And based on that, art is a form of copyright or a form of work that is subject to copyright protection. So if you want to go into more detail on copyright, just contact us, please.
Yeah, because if we're gonna talk literally about just copyright, and it's gonna be like a week-long discussion.
Yeah, it is. So copyright in relation to art is different to copyright in relation to music, and the principles are there, but the application is different. We need to make this clear, because else a musician's gonna be like, yeah, but Ezra said. No, Ezra didn't
No,
say.
I did not say.
I think the main issues you see in the industry as an artist, and again, we had this discussion, but what, if you have to summarize it, and if you have to have the discussion with other artists, but also, IP better than most artists, I know that, but what is the main concerns you see, the main issues, and the main questions that pop up?
It's the uncertainty about where it's actually placed in when an artist produces their artwork. And we often see it, or rather I see it since I'm in the industry, artists that do fan art, for example. Okay. I know, I've learned from Christiaan that it's not just free all. There is some really serious legal stuff behind it. But artists don't realize that fan art means that you are breaking the law.
Yes.
Unfortunately, that is the reality. And as you said when we chatted earlier, that in South Africa, or Africa in general, there isn't really something like a fair use policy or so that allows artists to technically create fan art. And that's really something I see a lot.
Okay.
Yeah.
That is actually a good topic. We also see a lot of queries and stuff about fan art, and the misconception there is. The problem is, a lot of people, and you touched on that, about in South Africa. The law differs from country to country. South Africa, we do not have fair use. There is currently, under current law, no concept of fair use in South Africa. We have fair dealing, which is a completely different animal. And why I'm saying this is, if you, as the artist, Google, you get American results, meaning you get results likely from a country that has fair use.
Yeah.
So you are getting inaccurate law when it comes to South African work and South African artists. So please don't Google. I beg of you, don't Google and take that as the law. Reach out to us. Reach out to other intellectual property attorneys that understand the copyright law. I prefer it being us for obvious reasons. But reach out to us. Go onto our social media. Go onto our links there. We also share a lot of information freely. There's a book you'll see in our links. I'll post it below. In the comments, there's a link which I'll share about a book specifically written by a bunch of people in IP and copyright way smarter than me, about the implications and aspects of the changes to the current Copyright Act, which you might see. To understand that, again, don't go and Google things. There's a lot of misconception and misinformation about the updates on copyright. But we don't have fair use. We have fair dealing. And under fair dealing, there is a specific exception to infringement. So when you create fan art, you are infringing. That is clear in law. But there's an exception that states that if that is done for personal use, it is okay.
Yeah.
But personal use is very defined. What is personal use? It is for my personal use. It's for me. It's not commercial. It's not selling it at a fair, or selling it online, or making it and on a commission basis, for instance, saying I can recreate Spider-Man, do you want it? And I can make it any way you want. That is infringement. It's not fair dealing. It's not an exception in South African law to infringement. Therefore, and I know this, people hate this if I say it, but it's the truth. If you create fan art and you sell that fan art, you are infringing the copyright of the original owner.
Yeah.
And that is the issue. But, I mean, we all know what the argument will be when I say this to an artist. And that is that, I mean, you've seen this. Yeah, but everybody does it.
Right, yeah. Everyone does it. I don't see anyone putting in implications, you know, fining me that I'm creating fan art. Like, everyone does it. It's all over social media. Everyone does it at Comic-Con.
Yeah.
It's always like that, yeah.
And that is, I think, part of the misconception that has been created, or that fuels this misconception. Disney is at Comic-Con. And there's so many people at Comic-Con that makes Disney fan art. And Disney doesn't do anything about him. So it's fine. And no, it's not fine. Disney, and again, we're using this as an example. So don't go to Disney and say they are doing this. Don't put Comic-Con on the spot here. We're using this as an example, please. Disney, as the owner of the copyright, has the right to enforce, which means they can choose, am I going to go up against this guy that maybe makes 20 a year?
Yeah.
Is it financially worth it? Is it worth the effort? Or am I going to accept that it's fine and just to look the other way? It still remains infringement. But the choice sits with the owner of the intellectual property, whether he or she or it, in the case of an entity, wants to enforce these rights, wants to go up against this artist that likely only does it for Comic-Con or a small scale. But they might choose to still do it.
Yeah.
The fact that the public or the general art public doesn't know about the enforcement that happens purely means they have Disney, for argument's sake, has good publicity. They know how to deal with it without making a scene
fuss, yeah.
at the thing. I can tell you, those guys go up against a lot of those guys. There's large discussions. Comic-Con is actually in discussion on those things with various parties, and they are looking at the infringement aspect and things like that. So it is still infringement. You can't say because other people do it, it is okay. It just means that it is looked over by the IP owner, which is their right. There's various reasons they might do it.
So here's my analogy as to why they just allow it to happen. It's because it's free marketing for them too, in a sense, right? But it's still, the reality is that it is infringement.
And I'm so glad you brought that up, because that's not only in copyright, but even in trademark infringement. We see that often where people say, yeah, but I gave him free publicity. Yes, but the copyright owner and the intellectual property owner has the choice of how that IP is used. So even though you, in this scenario, might feel, yeah, but it was free publicity.
Right.
It is still their prerogative to say, yeah, but I didn't want you. I didn't give you permission to do that. Take the argument and take art and convert it to something that people understand. Car. This is a car.
Yeah.
Take art, make it a car. Is it okay for you to take my car?
No.
Is it okay for you to drive the car?
No.
If you wash the car and bring it back to me, will I still be okay with you taking my car?
No.
Same scenario. But I gave you free publicity.
Right, yeah.
Yeah, but you still took it.
Yeah, you still
Used it. Plus, you likely still made money out of something that you actually don't own.
Yeah.
So, yeah, you changed it slightly, and you adapted it, and things like that. But it's still Spider-Man.
It's still Spider-Man.
And that look, it is a complicated discussion. It is a complicated situation, and I mean, turning the entire thing on its head. A lot of those people and those copyright owners have processes and platforms and systems in place whereby you can get authorization to do this, whereby you can set that it can be I'm not going to say fair use, but fair in their views for you to do the artwork in relation to specific predetermined parameters.
Yes.
Where you don't necessarily need to apply to do it. You must just stick to those guidelines they give you. So those options are there. And a lot of the art you see arguably could be under that. It could be under license, or it could be under I know some of the comic book creators, the Marvels, DCs, those guys, have, I want to say, it's sort of a recruitment system. It's not a recruitment system, but they allow certain artists with their permission to create.
Yes.
Because they are sourcing new
material,
illustrators. So but it's a system, it's a structured process that allows you to do this. And again, this is South Africa, I'm not saying America. And if you get, this now that cross-border thing, if an American company gives you permission in South Africa, do they do it under American law or South African law? And this is a question, I'm not going to answer that question. But the reason I'm asking the question is you need to be sure.
Right.
You need to get the contracts in place. You need to get the necessary permissions. You need to say, okay, well, here is the rules that Marvel, for argument's sake, gave me to do this. Am I sticking to those rules? And is those rules governed under American law or South African law or another law? So there's so many things you have to consider. Look, I'm overcomplicating it slightly. It's likely going to be very easy to do this. There's people and companies and processes to do it, and there's people like you that know more about the intellectual property area than artists starting out, for argument's sake. So talk to your peers, talk to other people in the industry. But still, it's not just this is cool, let me make it. But yeah, so fan art is a good point to use as an example. But again, it's just one of the examples.
Yeah, no, it definitely is one of the examples. And just one more thing on the fan art, though. Fan art, you start infringing when you actually start selling it, right?
No, you start infringing when you create it.
So when you create a fan art just purely to post on social media,
yes,
is it still considered as infringement?
Yes, so this is and this is something that a lot of people not versed in law struggle with. An exception to infringement doesn't mean it's not infringement.
Okay.
It means you infringe, but it's one of my exceptions.
Right.
So you infringe by creating it. The law just says it's okay if you do it under these circumstances.
Right. So if it falls under as personal use.
Yes. Then it's okay.
Okay, it's okay. But if you post it on social media and it's still it was done for yourself.
It's still personal use.
It's still
then
personal
it's okay.
use. Then it's okay.
So the exception is the personal use. Look, there's 5 odd exceptions, and there's very clearly defined exceptions. In this case, we're looking at personal use. If I draw a picture of Spider-Man and I post it on my social media, there's no commercial use in it. On not on the firms, on my social media.
Yeah.
It's personal use because I'm like, hey guys, look at this awesome drawing I tried doing. I'm not an artist, I'm nothing, I don't make money out of it. But the lines get blurred if you do it.
Okay.
Because you post on your social media for what reason?
Right.
To get followers, to get more business.
Self-promotion.
Self-promotion. Therefore, is it personal use or is it commercial use? Because remember, commercial use doesn't mean there's an exchange of finances.
Okay, yeah.
Commercial use can be using this without authorization to promote yourself. Now, I'm not promoting myself by using Spider-Man on my personal social media platform that only my few friends and family see, and they laugh at me because I can't draw for anything. That's personal use, clear.
Yeah.
I mean, that's a fairly obvious argument. In your case, it's a slightly more difficult argument.
Okay.
Because you post it on a platform where you are an artist.
Right.
Therefore, you are using it as promotion of your art, your skill, your service. Therefore, it becomes, or arguably might become, commercial use and not personal use anymore because you used it in a business setup. So be careful about that. Yeah, but I only posted it on social media.
Yeah.
Okay, but you posted, take Spider-Man or the fan art out of it. If I use an image of Let's take a famous musician. Let's say I go and I'm like, okay, well, here is Rihanna. I'm posting her image on my music channel. What do you think is going to happen? You're going to have a lot of issues because you are promoting a music channel through Rihanna who is not associated with that music channel at all. And I'm using the music industry because there's governed laws and governed structures in place on how the money flows and how the royalties go in. Please, musicians, don't start bombarding the comments. We can have a different discussion on the music industry. But you can't do that.
Yeah.
Now you're using a celebrity copyright image to promote yourself without the owner of that celebrity, and I'm saying the celebrity is Spider-Man in argument's sake, to promote your other work. Therefore, you are commercially using the image of Spider-Man in a promotional corporate environment to promote and further your own gain. It's commercial use.
It's commercial use, okay.
Yeah. Well, that would be my argument.
Right.
Again, there's so many variables and things there, but it is the moment you're an artist, be careful of what you do.
Yeah.
And I know, again, we admit there's a lot of people making money and making a living out of this, but it's still actually infringement. And yeah, but that's I think enough on fan art.
Yeah.
Again, that's one of those deep holes. If you jump down there, you go down for a while, and all of a sudden you're in Wonderland, but the cat looks different.
No, for sure.
So, yeah.
But I think that was a good dive in on really fan art.
And that's usually where the queries come in.
Yeah.
Because it's easy for people to quickly do, and I'm not trying to offend, but it's easier to make 50 Spider-Man versions or 50 Batman versions than it is to try and make your own and get people to buy your own art, because the consumer recognizes Spider-Man.
Yeah.
And this is now, and I remember we had this discussion in our first video about the AI thing is, yeah, but if I buy art, nobody knows, oh, that's a copy of Spider-Man. They're not going to know you as an artist. And I mean, you know, we've got some of your pieces in our office. Yeah, that's an Ezra piece.
Yeah.
Everybody, and if you ever visit our office, you'll see what the two pieces I'm specifically referring to now. Everyone's like, oh, that's awesome. Who made it? It's like Ezra. Why? Because they don't say, oh, that's an awesome Spider-Man. They see a piece of art and like, oh, my word, who made these?
Right.
It's like, oh, no, it's Ezra. Here's his details, blah, blah, blah. And that's ultimately what you as an artist would want. And now I'm saying this as a non-artist, knowing it's difficult.
It's definitely difficult getting that recognition that you feel like you deserve as an artist.
Yeah.
For all the hard work and hours of practicing and learning that you put into it. But I mean, long-term based, that's what you want. You want to be recognized in the industry. You want to be recognized by your followers and your fans, and want new people to learn about you. And I think really when you look at fan art, it kind of takes out a whole bunch of that. Be like, oh, well, that's awesome. One Piece, right? Fantastic.
Yeah, but who made it?
Yeah, Dragon Ball. Oh, cool. Akira Toriyama. Fantastic. It's not Ezra. It's, you look at that.
Yeah.
You know.
You're associated with the original artist.
Exactly. Yeah. So I do agree. That it definitely does take a sense of your individuality out of it, even though you are spending 20 hours 30 hours on a piece and it is in your own style. It's still just it takes away. So
takes it away, and that's the thing. Look, again, like I said a few times, we're not trying to offend or
not at all
point fingers at anyone. I love art, and don't get me wrong, some fan art pieces are amazing. So I'm not taking away from the skill. I mean, I've seen some of your fan art pieces that you did legitimately, I have to add, because you really have them as personal use. And it's amazing works. and you can see this is not the original artist. This is an adaptation of it in your style, things like that. But it's against your wall in your home. You did it because you love One Piece, or you did it because you love whatever one you want to go to. And I mean, you have some of those, and you tell people you have these because you appreciate the art forms and you appreciate that, but you don't make money out of it.
No.
You are purely a, how can I put it, a original artist.
Yeah.
If I can put it like that. And look, fan art has its points as a stepping stone. It's easy to practice. It's easy to get into style and things like that. But you use it again. That's a personal use thing.
So I mean, if I have to use myself as an example, I started out the business with fan art, right? Because anime got me inspired into character design, right? So I found that very interesting, and it's easier to learn based off those existing characters that you liked, right? And so yes, I did start out with fan art, and in all honesty, didn't do the best in terms of sales wise. That's why I moved away from it, because I've always liked doing more original work, right? So I moved that away. So it didn't become commercial anymore. It became personal, right? So I'm just doing it for myself, and I'm only focusing on original work. But I do agree, it definitely does have a stepping stone for many artists.
Yeah, and
many artists.
And I can't take that away. It's truth. It's a lot of artists, especially in the scenes we go. A lot of those artists started, and I'm thinking of Comic-Con specifically. Some of the artist booths there in the artist alley I've seen, first year they do a fairly decent rendering of a stormtrooper. Second year they do a way weird adaptation of a stormtrooper with a character I've never seen before. Third year, you don't see a stormtrooper anymore. All of a sudden it's this character and it's the style and things.
Exactly.
But they obviously got into it in some way.
Yeah.
It was a stepping block, and it's extremely valuable.
Yeah.
Bearing in mind the legal implications thereof.
Yeah.
And that's the scenario that we always need to consider. Is also, and I'm now preaching to the other attorneys that might look at this. Bear in mind when you're dealing with an artist, a lot of times they are not aware of the implications. Yes, ignorance is not a defense. I'm not saying because you don't know you can get away with it, but bear that in mind, that it might be completely innocent, and
Or they may just be misinformed.
yeah, they're misinformed, and a lot of times,
which is usually the case, to be honest.
When we see it, the moment we inform this artist, they're like, "Oh, whoa, we didn't know," and they stop.
Yeah.
They have no intention of continuing this infringement because purely they were misinformed.
Yeah.
They Googled and they found the wrong information. I think steering away from fan art.
Right.
What was the original intention of this discussion? Oh, your basics.
Right, just the basics about copyright and some IP in the art.
Yeah, and I think, okay, well, we had a discussion about fan art, so I think this is more fan art related thing. But maybe we can give some tips.
So, I think, right, where you could maybe help give tips, right, is I see this a lot, and where artists create original work, right, I create this character, right, and some company somewhere in Ireland or whatever, steals the artwork, right? It's public. It's public on social media, right?
Yeah,
it's on Pinterest.
It's not public, but
and it's on your website, whatever, right? So I see this often on TikTok or Instagram. Artists showing, oh hey, so my art's been stolen again. I've been trying to get in contact with them, but they're ignoring them or they don't want to listen to them, and most artists firstly cannot really afford legal right? Necessarily for you to help them with their designs or artworks or whatever being stolen. So how can they try and work around it?
It is a difficult question. That I mean, at the end of the day, if you want to enforce IP, there's a certain sense of financial implication.
Yeah.
Which is unfortunately the reality of the legal system throughout the world. But I think information would help. Let's look at copyright. So when we have copyright, you've got two main things to consider. Your own copyright that you own, the protection you have in your works, and then the protection other people have in their works. I think we went enough into the copyright aspect on fan art. Other people have protection. You cannot infringe that. There's implications if you infringe. Now turning that towards you. You create this. You create your book. You create your characters. And you have copyright in both the book itself, but also in the characters you design.
Right.
Two different forms of copyright protection, one for literature and one for art. So how do you go about protecting copyright? Nice thing is it's automatic.
Okay.
Unlike the other forms of intellectual property, patents, designs and trademarks that you have to file formal registrations, and again, please, I'm focusing on South African law here. Copyright, except for films, copyright in the sense of this is an automatic right. The moment you create it, you own it as the author.
So once you create it, you publish it,
No, even before you publish it. Once you create your art, you own it.
Okay.
But now you have to prove that you own it.
Right.
And how do you prove it?
I'll probably say process, videos, photos.
Yes.
Stuff like that.
The creative process proves it. You can't say, but here's my book, I own it. Okay, great, you've got your book. Your book was published 2023. This artwork that the company stole is 2022.
Right.
How do you use your book that postdates the creation? Here's illustrations, and I know your process. You post the illustrations, sped up, thankfully, but you post illustrations in the creation of I'm very fond of this character because I saw her development from scratch, from a stick figure drawing up to, and again, if you want to know what I mean by stick figure drawings, go follow Ezra. His links are down here. But you created it. It was a long process.
Right.
Somewhere during that process, somebody might have seen, oh, wait, I like this, and they adopted it before you published your book. However, that process, the renderings, the artwork you have, proves that you owned it. You created it before they even started posting it.
Right.
And a nice thing about the digital age is proving content now. Establishing a timestamp in a digital file. You can't really amend that. The timestamp is there. Yes, you can rename it and but the creation date is stamped. It's a digital stamp.
Right.
And you can go into deeper aspects of that and start using extreme technology to create that burden of proof. Or you can email it to me, and we put it on file, and it doesn't cost you something. But then there's an email where we can go back and say, oh wait, on this date this was emailed to us. Right. So at least on this date we can prove there's a stamp on a date, and we received these documents this day. So there's things like that. Please don't bombard us with emails. First contact us and come on board formally as a client before you start bombarding us with your art. We like it when you do, but follow the process.
Right.
But proving it is keeping your napkin drawings is essential sometimes, because all of that entire creative process has it, and saving regularly, not over the original, not auto saving over one file, because then you only have one file. Right. Saving separate iterations throughout your process. Just get into that. When you're done for the day, take that version, save them in a separate file in a small format. Don't go massive. Just here's how far I came today. Save it as a PDF or a JPEG or whatever format you want, but there you go. And remember, law is not technical, therefore you can't give them here's the raw file. Save a JPEG that we can print out and take to a court that still wants physical documents. But do that. Just build this body of work and a creative process, and that proves it. And then, once you've got that, enforcing becomes easy.
Okay.
Because now all of a sudden you can go, and the court of public opinion is awesome if you do it right.
Okay. So take notes.
Yeah, take notes. And again, this isn't legal advice. This is purely just a discussion.
Right.
If you want advice, contact us. Every single case differs. Therefore, we would need to give you advice on it based on what's happening in your case. But taking that case that you said, a company overseas stole the character for argument's sake, you can then start engaging with them yourself. Always tell people, start engaging yourself. Nice. Be nice about it. Because remember, that company might be in a country where they have fair use, and therefore they might apply law differently. But you're a South African artist, therefore you have South African rights. Look, at copyright as an international reach. You have that to your advantage. And then you reach out civilly but formally to them and just say, hi guys, this is my artwork. You literally just stole it. What the hell?
Yeah.
Obviously don't say what,
right.
Just be nice about it. And then see what they say. If they then refuse to acknowledge you or accommodate you, ignore you flat, then reach out to us. The entire process might be expensive, but for us to send them a formal letter is not. It's not going to break the bank even for an artist.
Yeah.
We then reach out to them and say, well, paint it in a more illegal term, but here's the scenario, here's how it is, this is our client, this is, we paint a picture to them and tell them, you're infringing our client's rights. Please stop. And then what we also tell our clients a lot of times is don't go and fight and say, remove it. You might just want them to be like, okay, you're already using my artwork, therefore just give me the credit and pay me what I'm due. There's a new client for you.
Right.
So a lot of people, and this is not just in the art industry, we see this throughout, they want to fight. And a lot of times fighting is the last step. Remember this in any litigation, your fight is your last step. Trying to settle is a better option. Trying to get something. They're infringing, but what would you have charged them to actually use yours?
Right.
Let's take that approach. Let's tell them, listen, you took my art, you messed it up, you're infringing, but as one of the settlement options is I can actually render this for you properly in accordance to what you want, but this is the fee. So you get paid. You have automatic client, likely, but that might be a simple scenario where you're like, okay, don't fight with them. Just say, guys, you're using my art. I see you try to render it. However, can I not just create one for you properly and you pay me what I'm due? I'm not saying do, but that's a scenario.
Or let's say they're using my artwork for products, right? T-shirts or something.
Yeah.
Maybe ask for a royalty.
That is a brilliant source of income.
Yeah.
Guys, you're making money out of my art. You're selling your T-shirts for $100 each. That's production costs, blah, blah, blah. So say, for instance, your profit margin is 30%. Give me 5% of it, or 10% of it, or 3% of it.
Yeah.
Maybe that company rolls out 1 million units a year.
Yeah.
$1 times 1 million.
It's
a lot of money.
Right,
I wouldn't mind doing
that. Right,
no,
definitely not.
Because $1 million but that is a good scenario because we use it in other forms of intellectual property infringement often, where we settle based on continual infringement, just do it under our rules and pay us our royalty. And look, the court of public opinion thing is also, it is valuable. Recently there was a case, and I won't mention the merits, but some people the parties, but some people might know what I'm talking about, where a large South African retail company in the furniture industry used certain images of a photographer without his permission, and that case was dealt with in between the parties because the negative impact on social media that had on the company wasn't worth it for them, so they settled. I'm not saying go and fight, because don't say hulle sleg. Don't go and be like, oh, there's just that photographer had a very subtle approach about, guys, I'm here in the shop. This is my photo. This is my photo. What the hell? And then the public sorted it out to an extent where the retailer had to pay to the party. As far as I'm aware, no attorneys had to actually be involved in that settlement. I might be wrong. I wasn't involved in the case, but sometimes something like that, just a pure informing them that they are infringing, might do what you need to do. Because all of a sudden it's like, oh, no, whoa, we don't infringe. This wasn't intentional. Yeah, it was. But okay, fine, then let's settle this. So I think in summary, don't always think that only attorneys are able to do it. Yes, don't try and do it yourself necessarily. But there's things you can go through before you need to involve an attorney. And I mean, you've dealt with me enough. Dealing with our firm, it doesn't break the bank. No. In some circumstances, we deal with stuff, and the invoice at the end of the day is, oh man, just do something for us. Do a nice wall piece, or just go, you've got a massive amount of followers, so come sit and chat with me. Stuff like that. So we are accommodating because we are focused on the creative industry as well. So sometimes it's worth reaching out to us. Just, hey, what should we do here? But don't always go to the fight. Like you rightfully said, you might be able to make a buck licensing from it, and then we help you with the license negotiation, getting the appropriate license in place. So I think, it's you can do things, even though it's this David versus Goliath situation. David won that fight, by the way. Just remember that. So don't go up against this. Don't think because it's a massive international company, I'm going to lose, so I shouldn't fight. They've got a lot of things to lose because they are a big company doing this. And again, they might do this in onkunde. They might not be aware. And it sounds like a cop-out, but really, they might not be aware. It might be a third party that proposed it to them, and they are using it, therefore they're infringing. But
no, that is true. Actually, one of my friends in Cape Town, I'm not going to say names or anything like that, but runs a merch company and stuff. So one of the artists that she had provided an artwork for her, which wasn't that artist's work. Right, so selling another artist's work, that's
a no-no.
That's terrible. Honestly, that's low, right, for an artist to sell another artist's work. But in any case, and that was brought to her attention by a few people in public. She was, oh crap, I really had no idea. I mean, I bought this from the artist, right? But just rectifying it and say, sorry, I'll remove it. Any merch related stuff that I've created from it, I'll give away, or I'll reduce the price by like 70% or something like that, right? There's always ways, that's reality that not everyone always knows.
That's the thing. The person that infringed does legitimately sometimes not know they are infringing. And that you as the owner should also take into account. That they might be accommodating. They might like, oh crap, I sold 100 shirts. Here's your cut.
Right. Yeah. Exactly.
They might. I'm not saying they're necessarily going to, but they might. Yeah. So I think what you need to know is just remember there is things you can do without breaking the bank. And then I mean there's a trademark aspect that just remember. I think the only thing we need to chat here is you as an artist have rights in your name, your I mean, bonsai. We know, we both know about bonsai. His signature is that looks
Right.
like a BZ or a BS stamp. That's a trademark because it's his signature. It's your brand. It's your Nike tick, if I can put it like that. Not endorsed by Nike. Your tick on your artwork. And therefore you have Ezra. I mean, Ezra's not your name. We all know that.
Yeah.
But Ezra is your brand.
It's my brand.
And therefore Ezra becomes the brand. And the iconic characters you have might become your... Because and why I'm saying that is Spider-Man, Batman, Superman... Weird Afrikaans song just popped in my head, which I hate myself for. But that if you don't know the song, you're not South African.
No, definitely
not. But those characters are filed as trademarks. Therefore, you could have the same. I mean, you created I Know for us. If you don't know I Know, again, there's a link below. But you created I Know for us, which is an awesome character that you created for us. And I Know is registered as a character, as a trademark, a shape or a likeness. I Know's likeness is registered as a trademark because it became part of our firm's brand. Yeah, there was commissioned and there's a changeover of IP and things like that, which again, we're not going to deal with now. But those elements, you as an artist can protect through trademarks, which gives you a further easy enforceable right. And again, it's not as expensive as you might think. So bear that in mind. I think that's the other thing we can chat. But yeah, again, like every time I talk to you, it's like, we need more time.
I know, right?
But I think we're leading in there where I know we've got one viewer who's a brilliant guy. Hi, you know who you are. He always phones me afterwards and like, I fell asleep halfway through. But he watches it like at 1 a.m. But
yeah.
So I know we should maybe wrap up.
yeah. But I think we've gone through quite a few really important points.
Yeah, definitely.
That an artist just needs to know about.
No, definitely.
Yeah. Education is key. So.
That's true. Education is key. Hence the reason for this segment.
Yeah.
But on that, quickly tell us a bit more about your book.
All right.
Yeah.
So my book, How to Draw a Character in 808s, is compiled together with weekly sections. So, for example, week 1 is learning about shapes, week 2 is learning about anatomy, and so forth. And the book is structured in a way that when you start learning from week 1 until the end of week 8, you'll be able to go from drawing a stick figure to drawing a basic character with some proportionates that's actually pretty decent, knowing some color theory, knowing how to draw some clothing, how to create just an epic character. And although the book is mostly meant for artists just starting out, just starting to learn character design, it's definitely a good book for intermediate artists as well that just wants to improve on a few things like eyes or perspective, some great stuff like that. And the hands, right?
Yeah, you need to give this to the AI generation,
right? Yes,
because
I think
none
I need
of
to
them
teach.
can create hands. So let's.
They need to hire me to learn the AI for hands.
Don't steal this. But yeah.
Yeah. So that's basically really what a book is about, and there is actually for each week there's practice, makes improvement pages where. I give you a few exercises per week to learn and teach. And I think one of the things often with these sort of type of books that you'll get is you don't really get a good practice page, right, for each section that's available. So I've really tried to push in there. And in the end of the book as well, there's some bonus features that gives you some perspective on career opportunities in character designing and animation and all that sort of stuff.
That's cool.
And how to build your portfolio for school or university, or when you want to, do some job hunting.
Cool.
So that's basically what the book's about.
So it's basically aimed at anybody wanting to draw.
Yeah.
That's awesome.
Yeah.
I know it's online, so you don't need to. But I think again we'll post it in the comments here where you can get it. But it's awesome. I remember when you started with this, we checked, and I couldn't find something similar to this, and it's a proper book.
Thanks.
So. Maybe my stick figures will get better.
I'm sure it will.
But yeah, gotcha. I like it, and I mean, you own the copyright in this.
Yeah.
And the nice thing is, I'm gonna give people homework. Go buy the book. It's not expensive.
No.
Check it out, and then you will see there's a few characters and a few examples in here of other people's stuff.
Yes.
Which is fine because there's an
educational.
exception. There's an exception to copyright. So go check it out, and if you've got questions on drawing and stuff, push it his way, and if it's regarding IP, push it both of our ways, because I know he actually has the ability to answer some of the basic questions. It's really thank you again, as always. I love our discussions.
This is just a great
if we
discussion.
recorded every single one, we would have had a Friends-style series.
Oh, I'm telling you, entire season full of series.
Oh, it's gonna be. Or nobody will watch it. but still, Thank you for coming.
No, thank you for having me.
As always, thank you for watching. Yeah.
Thanks, guys. Enjoy.
And before I forget, none of the things here was to be seen as legal advice.
Just a discussion.
It's just a discussion. I like that. I'm going to use that. Just a discussion. You're going to be a pop-up in every single video.
That'd be hilarious.
Okay. Cheers.
Cheers.